All right, the clerk can call the court to order, please.
The Court of Appeals for the 8th District of Texas is now in session.
Thank you. Welcome, counsel. We have one case on our docket this afternoon, Hugo Martinez et al. Versus David Boone et al. From Reeves County. Speaking for the appellants, Ms. Levy, I understand you're going to make the presentation. Is that correct?
Yes, Your Honor.
Okay. And then for the appellees, Mr. Allen will go first. It takes 17 minutes. Is that correct?
Yes, Your Honor.
Okay. And then Mr. Rincon will have 8 minutes for the balance of the appellees' time. And so with that, Ms. Levy, we're ready to start whenever you are.
Thank you, Chief Justice Alley, and may it please the court. In deciding this case, the court should be guided by two main considerations. The first is the clarified vicarious liability test from Painter via Ramirez drilling. And the second is the summary judgment standard. I'm going to focus my argument today on the vicarious liability test, and we will rely on our briefing for the other points unless the court should have questions. I'm going to turn directly to the two-part test from Painter. And I know typically when we discuss this test, we start with the employment relationship and then move to course and scope, which is of course how we briefed it. For the argument, I'm going to go backwards. I'm going to start with talking about course and scope. And I think it's important to really look at how this test came out after Painter. And we know a couple of things. We know that it's an objective analysis. And we know that we're looking divorced from the employment relationship and right to control. And we know that we're looking to see whether the employee was performing tasks generally assigned to him for the furtherance of the employer's business. Now, of course, in this case, we're looking at a special component of that, the special mission exception to the coming and going rule, which also was adopted into the common law in the Painter opinion. And the special mission test is going to look at whether the employer is performing regular or specifically assigned duties for the benefit of the employer. And another way of saying that is whether the employee is performing service in furtherance of the employer's business with the express or implied approval of the employer. And we know that this is where the summary judgment standard comes into play. This is a very fact-dependent test that depends heavily on the circumstances of each case. And so, of course, in this case, we have what we would call the special mission is our employee who is working at a remote oil and gas location, which is a 3-hour round trip from Necessities. And he is traveling on the evening that this collision occurred to get necessities, water, ice, and food that he needs to do his job. And so just tying that specifically to the test, we look to see whether that was part of his regular or specifically assigned duties. And we have evidence that it was. The employee himself said that he went into town that evening to get groceries, food, and water that he needed to continue his job. We have our Juan Valadez, who was sort of the captain of the ship for Cameron's purposes on that drill site, acknowledging that the employee was going to get food, water, ice, and also acknowledging that this is something that the employees did as a matter of course at this location. Water was not provided by Cameron or Boone, and the Cameron and Boone workers who were out there testified that they had to go and do this 3-hour trip to get water, 1, and 2, that they shared the water amongst themselves, which I think is important in terms of looking at this as really a job duty, because they're not able to do their job without water. And I don't think anyone really disputes that. And so they really are furthering their employer's business by going and getting the water that's not being provided. Now, I know, because these are such fact-specific inquiries, it's hard to point to a single case that is directly on point. I think the closest case we have is the Janet case, which did arise in the workers' compensation context, where we have the employees, they're on their way from, I think, their residence, their temporary residence, to the drill site, and they stop to get ice. And the question is getting ice for water that you need to do your job something that can be construed as being in the furtherance of your employer's business? And the Texas Supreme Court in that case, at least for workers' compensation purposes, told us that it was. But I also want to kind of touch on the concept of release, because one of the disputes we see coming out of the briefing is this notion that the employee was released on the evening of the accident, and therefore he could not be either an employee, either the employment relationship had ended, or he was no longer in the course and scope because he was released. And I think the confusion on that point in terms of how that's viewed really underscores the problem with looking at release, at least in terms of proving the issue at summary judgment. Because one, release is not a defined term. It's not a legally defined term in the authorities that we can tie to one of these tests. And it's not even a term that the parties themselves had defined in a written document or something that we can look to. And so the problem that you have with this release notion is that you're reliant upon the subjective recollections of all of these witnesses and their sort of subjective interpretation about what it means to be released.
Counsel,
so, yes.
if I could interrupt you, I thought Mueller was pretty clear when he said he was released, that for him the job was over. He could go home. He chose to stay because he thought there was the possibility that they would be picked up for another well. But I didn't really read the record to suggest that there was a great ambiguity about what the idea of release meant.
Well, I think there is, because you have, respectfully, Justice Alley, because you have, for example, Juan Valadez, who was an undisputed Cameron employee. And he was really the one who was telling Mueller what to do at the job site. And Valadez said that he was released. And so from that, are we going to infer that Valadez was no longer an employee? Of course not. He came back and worked the next day. So you can be released from your employment relationship. You can be released from the job site. But I think for summary judgment purposes, the important part about that specific testimony that you're referencing is it's contradicted even by Mueller himself, because he said he was released. He said he could go home, but then he turned around and went to the grocery store and bought 4 days worth of groceries and food and ice. Obviously with the expectation that that job was going to continue. Now, that's a credibility determination for the jury, right? This guy's testifying. It's his employer that he's testifying against. And I think based on what he did, a jury could conclude that perhaps he wasn't either recalling correctly or being truthful when he said, I was released and I thought I could go home. And I think in addition to his testimony, and it's not even just his testimony, I mean, he's got a written statement that he gives after the accident where he says, I was going to buy groceries. In addition to his testimony, you have the testimony of everyone out there who was working with him. Mr. Valadez, Corey Johnson, who was the night shift counterpart to Mueller, and they all indicated that they thought they were going to be put on standby to go on to the next drill location, and not drilling, but flowback work, the next location. So they were going to the Blue Heron. And so I think part of this concept of release, as opposed to if he was free to go, well, the fact is he went and bought groceries because he thought he was going to stay. And there's other witnesses who indicated that they all believed they were going to stay. In fact, Corey Johnson actually billed for standby pay, and Boone paid him. And then when Cameron said, no more contractors on the job site, that pay was taken away. And it's also important to look at Valadez's testimony. He thought he was going to be put on standby. And in his estimation, the only reason he wasn't was because of this collision. So
I'm sorry to interrupt you one more time.
you're fine.
Is there anything in the record that describes what this standby status means? In other words, if you're on standby, where are you supposed to be? Is there somebody supervising you? What rules or restrictions apply? Because obviously, when we're talking about vicarious liability, there has to be that element of control, the Wolf case that justifies imposing the liability on the employer. And so I'm just, because I didn't find any cases that talked about vicarious liability in relationship to somebody being on standby. There are some cases in Texas on somebody being on call, and they seem to be a little bit all over the board. But I'm just curious as to whether there's something in the record on that.
I think there's not any one thing that, much like release, there's not one thing that I can point to in the record that's going to clearly define what standby is. I think Valadez testified that, you were put on standby and you were paid maybe half your rate to stay around. Certainly Corey Johnson believed he would be paid for standby because he billed for it. And certainly, Cameron, or Boone rather, was familiar with the concept because they initially paid him. In terms of control, they're still staying on location. Even if he was on standby, he being Mueller, even if he's on standby, he came back and was still staying at that at the site and in the temporary housing while he was waiting. Now, after the collision occurred, ConocoPhillips asked everyone and all of the contractors to leave. So at that point, there was what they call a man camp that I think is further in town. I don't know the exact location. And that's where they went to wait before they moved on to the next location. But I would say even, again, we're not talking about, well, for the purposes of course and scope, the issue is whether they have the right to control. It's divorced from right to control, right? So it's merely, are they doing something for their employer's benefit with the express or implied approval of their employer? And so if they're on standby, they're contemplating going to the next location, which was the Blue Heron. And part of it is the nature of this work in general. These guys aren't typically going out there for a 3-day job, for a 4-day job. They're going out there for a longer period of time, and they're hopping, they call it like hopping pads. And they go to different locations because flowback work is kind of a discrete, it's a discrete part of the drilling process. So it's necessarily only going to last, for a few days to a few months, we know from this. And we know in this case that Valadez, the Cameron, employees and the Conoco employees actually did go on and work at the Blue Heron site. So that actually took place. But at that point, Cameron, because recall by contract, there were not supposed to be any contractors out there. And when Cameron found out that there were contractors out there after the accident, they asked all contractors to be removed. And so I think there's two ways to look at the evidence. Either he was released and then the accident happened, but I think there's much more support. And certainly, again, at summary judgment, there's evidence to suggest the accidents happened and then the decision was made to release these employees and have them leave, not the other way around. And again, that is something that the jury should be able to consider when evaluating course and scope. I want to go on and discuss the employment relationship. Again, we believe there are fact issues as to the employment relationship with both Cameron and Boone. Of course, with Cameron, we have this contract. It's set out in our briefing, a unequivocally clear contract where they agree that anyone who comes to work on this location is going to be considered their employee for all purposes. Now, at the very least, that contract is something that the jury should be able to consider in determining whether an employment relationship existed. And again, when we're talking employment relationship, we're looking at a general analysis, not task-based, and we're looking for the overall progress, right to control, progress, methods, and details of the work. And so we have the contract, but I think in this case, even without the contract, we have evidence sufficient to create a fact issue on whether there's an employment relationship. I'll start with Cameron and then discuss Boone unless the court has questions out of order. As to Cameron, again, part of it was we have to look at what they're doing here with this flowback testing work. A flowback is sort of a discrete step in the drilling process, right? You've fracked the well, and I'm going to oversimplify, but you put the water down, you've created the fractures, hopefully the oil and gas is flowing out, and with it is coming the water, the sand, and all the stuff that you use to frack. And so you've got equipment, you've got a separator, and that process is taking place, and you need people there to man that equipment 24 hours a day. It's not something you can leave, nor is it something that you can easily shut down and start up like you would, a building project or something like that. And so what these employees are doing is they're monitoring the equipment, they're taking readings. In this case, we know every hour they go, they take a test, they write it down, they do a report. They're required to do this for 12 hours. They're paid a day rate. So they're paid for a 24-hour window, but they typically are doing their readings for 12 hours. And then when they're not doing their readings, they're still on premises in the trailers sleeping, barring something going wrong where everybody needs to come out and help out, which is something that can happen with flowback work because you've got stuff flowing out, equipment can malfunction, you can have a blowout, a washout, and at that point, it's sort of an all hands on deck type of situation where all of the people that are there are going to go help. By design. But typically you have a 12-hour shift, and this is not something that you have discretion over. When I say you, I say Mueller and the employees. This is not something that they have discretion to start and stop at will. They cannot at 12 o'clock noon decide that they want to take a break for 2 hours to go into town and get themselves some water or food or lunch. They have to stay there for that window. And in this case, especially with respect to Cameron, from the people that were on premises, we have testimony indicating that Juan Valadez, who was the sort of Cameron, he was the highest person on the chain for Cameron who was at this location. And he worked during the day with Mueller, who is the gentleman that caused the collision. And then you had a similar Cameron Boone sort of night shift, and they would do the same things at night. And so Valadez was in charge of everyone. He was the most senior person there. And he was in charge of Mueller, and he told Mueller what to do. And then during the night shift, you have, the same sort of arrangement. Again, equipment. I know we talk about, obviously we looked at the limestone factors when we're making this analysis, we address that in detail in our briefing. But I really want to point out here, again, you're looking at the overall right to control, the progress methods details. And so I know we can sort of have arguments about whether, okay, he brought his own hammer out there, but they supplied certain equipment. But at the end of the day, again, turning back to our summary judgment standard, there is absolutely testimony on this record that they had the right to control him while he was at the job site. And by they I mean Cameron. And then turning to Boone. Now Boone is Boone, I'm sorry, you had a question, Justice Alley.
Yeah, I mean, Boone's kind of interesting. I mean, the record, he's described as a headhunter or as a broker. I recall my days from litigation, there used to be these services that you could call and they would go and find an expert for you. You would deal directly with the expert, but they would kind of handle the billing. That's almost kind of what it looked like. And I didn't really see any cases in the briefing that addressed the vicarious liability in a situation like that, where you have, in essence, a headhunter or a broker.
Right. I mean, when I looked at it initially, it almost had shades of borrowed servant, but there wasn't a contract between these two people, between Cameron and Boone that we can look to sort of formalize, determine what they believe their relationship to be, at least prior to litigation. But I think when you look at Boone's testimony, I mean, that's where I look because you see how he viewed it. And of course he has, with Mueller, this one-page contract, but the contract doesn't really discuss right to control. It just says you're an independent contractor, and it has some verbiage about insurance, which I wasn't necessarily followed, because Boone then testified that he provided these guys workers' comp insurance, which wouldn't be synonymous with someone, necessarily who's just a broker. And it's not like he just brokered them and then, and then they work directly for whatever company he sent them out to. But again, turning back to his testimony, he kind of refers to these guys as they were out there working for me, when they came to work for me, when, he says he would call Cameron and sort of check up to see how they were doing. And he indicated that, he had the right, I think critical for our test, he had the right, if they weren't performing, to ask them to leave, because it reflected upon him. And then he even in his deposition went so far as to say that if they, committed, if they, I don't know the exact words, so I'm paraphrasing, but if they did something wrong at the job, he would be responsible. And he actually admitted that in his deposition. And there's kind of a whole line of questioning where there was follow-up questions and he was instructed not to answer. And so we couldn't get, too far down the road with that. But, he at least saw them as his employees in some sense. And again, we're looking to, does he have the right to control, not whether he actually chose to exercise the control.
So does this mean that you see it as a jury question to determine the employer, or can you be the employer of both, or the employee of both? I'm sorry.
Yes,
he can be an employee of both, Cameron.
Yes, I would say he can be an employee of both if they both have the right to control what he's doing. And he could be one, both, either. I think this is something, obviously if we had a contract, it would maybe be different, but I think this is something based on the testimony that we have that the jury should really be able to decide. And again, our standard is this something that should be taken away from the jury? And in every aspect of both of these tests, we're relying on a lot of testimony from witnesses. And a lot of these people who are testifying they're testifying for their employer. And so a jury should be, and a jury is free to say, no, I just, free to disregard what they're saying when they say they were released, if it's at odds with the fact that they then came in the next day to work. Again, these are sort of the hallmarks of what juries do and what they decide. So I see I'm close to running out of time. So unless the court has any questions, I will yield the rest of my time and revisit at rebuttal.
Thank you, counsel. Mr. Allen.
Thank you, Your Honor. May it please the court, Thomas Allen for Applee Cameron International Corporation. Summary judgment record in this case is large, but the key facts are few and uncontroverted and require affirmance. And it all gets down to $38 worth of groceries. That is what John Mueller bought at the Walmart in Pecos on the evening of June 8th, 2015, after eating dinner and before returning back to the Blue Marlin well site, where he was staying for his own convenience and not as any part of his job. In fact, that job, which lasted 4 days, had ended hours before. Mueller bought these groceries on his own time, on his own initiative, with his own money, and drove his own truck back to the well site in case a new job became available the next day, a new job at another well. And it was during this drive back that the tragic accident in this case occurred. Plaintiff's entire basis, their entire theory, Cameron vicariously liable for Mr. Mueller's negligence, hinges on the idea that this small grocery purchase, supplies Mueller bought only for himself, as opposing counsel has just acknowledged, transformed a personal errand by an off-duty contractor into a special mission for Cameron. As a matter of law, these uncontroverted facts do not create even a fact question of a special mission, and the court should affirm. Now, as we explained in our brief, the court may affirm on a number of grounds, and perhaps the most straightforward is the fact that at the time of the accident, Mr. Mueller was no longer working for Cameron in any capacity. His job, the job he had been hired to do, was done. Now, legally, there's no confusion about this. As a matter of law, there can be no vicarious liability for the torts of former or even off-duty employees. Here, plaintiffs didn't even really challenge this ground in their opening brief, but let's look at the facts that are uncontroverted. Mr. Mueller was hired to do one job and one job only, flowback well testing at the Blue Marlin well site. At page 13 of their reply brief, they acknowledge that was done at the end of the day shift on June 8th, hours before the accident. Mr. Mueller was not hired as a general purpose roughneck. He was not hopping pads. He was hired to do this one discrete job, which ended. Now, the testimony from the witnesses is unanimous that, and while they use different verbal formulations, again, this isn't, there isn't some fact question for a jury to resolve. At the end of his shift, Mr. Mueller was released, meaning he was gone. He was done. His job was over. That is not a source of confusion. And he, as Chief Justice Alley, you pointed out, he was unequivocal about that in his testimony. About what would happen the next day, he said he could go home. He could leave that night, and no one contradicted him on that. He stayed first because it was too late in the evening to drive 8 hours through the dark back home to the Dallas-Fort Worth area. And Conoco had told him another job at another well might become available the next day. So he stayed to keep his options open. And that is why.
Mr. Allen, let me just, you said Conoco told him or Cameron told him or Boone told him?
His testimony is that the Conoco supervisor told him that there might be another job at another well site, but it was unclear. They would confirm that the next day. So it would be this was not a direction from Cameron. Now,
okay,
that is what Mr. Mueller's unequivocal testimony as to why he stayed. He is not. He's not contradicting himself, as opposing counsel suggested. He was very clear that is why he stayed. And so, and there's no other fact question to dispute that he was somehow still on the job he was hired to do. He was only staying around in case another job at another well site materialized. For example, his statement to Cameron after the accident, he stated a company man, Conoco, asked, did not order, the Boone hands to stay. That's entirely consistent with his testimony that Conoco said there might be another job. We'll confirm the next day if you're interested. Nothing in that statement says Cameron ordered Mr. Mueller to stay or that somehow he still had work to do on the job he'd been hired to do. Now, there was a fair bit of discussion back and forth about the question of standby. Again, this does not create any fact question that Mr. Mueller was still on duty or planning to go to work the next day. It's undisputed Mr. Mueller never went on standby. It's undisputed he was never paid for standby. The record evidence is clear. He invoiced only through June 8th, and his shift was over at 6 p.m. on June 8th, hours before the accident. Now, there is testimony from Mr. Valadez saying that they might go on standby, quote, for the next well, not the job Mr. Mueller was hired to do. And he goes on to say that, Mr. Valadez goes on to say that for contractors like Mueller, standby only applies if they agree to it. He states they can just go to another job because they're not obligated to stay working with us. That doesn't sound like someone who's an employee still working for Cameron, or even a contractor still working for Cameron. It was Mr. Mueller's choice whether to stay or whether to leave. And so therefore, and Mr. Valadez agrees, at the time of the accident, Mr. Mueller was on his own time, running a personal errand, not working for Cameron or anyone else. But if the court believes there is some fact question about whether Mr. Mueller's work had ended on the night of the accident, the court may still affirm, because Mr. Mueller was the quintessential independent contractor. He was never a Cameron employee. Again, let's consider the uncontroverted facts. Mr. Mueller was hired through a placement agency, Boone, and it was his company, H&J, that was hired as the independent contractor. He was the employee of H&J. He had one job, which lasted for 4 days, and when that job ended, his payment ended. Now, the testimony from Mr. Valadez and others is clear and consistent that Mr. Mueller knew his stuff. He had experience. He did not need special handholding or supervision to do his job, and by all accounts, did a good job. There is nothing inconsistent with a general contractor or someone else giving an independent contractor specifications for the job, assigning particular tasks, setting their work schedule. All of that is consistent with someone being an independent contractor.
Mr. Allen, if I can interrupt you, my problem there is you have a contract between ConocoPhillips and Cameron that says that everybody who Cameron has on the work site is going to be their employee. And I read the cases that you cited in your brief to try and differentiate that, but then I kind of went back to Painter, and in Painter you had Sandridge had a contract with the Amerimex, and a provision of that contract says that Amerimex will have one of its drillers drive the crew. So, contract between, I guess, general and contractor is dictating what happens with a particular employee. I mean, isn't that the same thing here? You have a contract with ConocoPhillips and your client that then influences or controls, what the status of one of the workers on the work site.
Well, respectfully, Your Honor, I would submit that these are very different situations. Here, this is a master services agreement, which, as the court is undoubtedly aware, are commonplace in the oil and gas industry. The purpose of this contract, undoubtedly, indisputably, is to allocate risk between Conoco and Cameron by having Cameron, any workers on the work site, employees or contractors deemed employees of Cameron, that shifts the risk to Cameron vis-a-vis Conoco. Plaintiff's theory is different, and it's different than the contract in Painter, because according to them, a contract between two parties can divest a third party, a non-party, of their rights and transform an unwitting independent contractor into an employee. Now, they don't cite any authority for that. In Painter, Mr. Burchett, the driller, testified that he wouldn't have taken that job unless he had gotten the bonus, unless driving the truck between the work site and the bunkhouse was part of his job. Here, Mr. Mueller had taken great pains to become an independent contractor. He had jumped through all the procedural hoops, and there are perks to being an independent contractor: tax benefits, insurance benefits, scheduling flexibility benefits. It would be a surprise to independent contractors across the state of Texas if a contract they were not party to and had maybe never even saw would transform them from contractors into employees. And maybe we can step back and think about the implications of the argument the plaintiffs are making. Let's say that instead of the accident on the highway, Mr. Mueller, there was an accident on the well site. The sand separator blew up and Mr. Mueller was injured. Mr. Mueller sues Cameron for negligence, seeking actual punitive damages. Now, if Mr. Mueller is our employee, he is limited by the exclusivity provisions of the Workers' Compensation Act to a more certain but lower recovery. If he's an independent contractor, he is not limited to that exclusivity provision. Now, in response to such a lawsuit, could Cameron really hold up the MSA and say, aha, Mr. Mueller, little did you know, Conoco and I decided 7 years ago that you were actually our employee, and therefore the only recovery you can get is under the workers' compensation statute. Could they really do that? According to plaintiff's theory, they could. And I think that explains why this is really an apples and oranges argument. Finishing up on employee versus contractor, if I see my time is running short, I would just note that first of all, the effect of a contract is a question of law, not a question of fact. There was a reference to the trailers. As we explained in the brief, there was no requirement that Mr. Mueller stay in those trailers. That was a question of for his convenience only. And of course, it was more convenient than staying in town and driving back and forth. But no one made him do that. He could do that.
Can I ask you, as far as with regard to these trailers, you're describing it as being just a convenience to him, but I would imagine those are controlled facilities that not just anyone can just decide to stay there for the night. That you must be, allowed onto the property under some status.
I think that's undoubtedly the case, Your Honor. And as a contractor, he was permitted but not required to stay on the Blue Marlin well site during those 4 days. But he testified, and no one contradicted that he could stay somewhere else. And
but then wasn't there some testimony in the record also that he had an obligation then to clean out his area?
There is, yes, Your Honor, there is. And
so how does that relate to the idea that if he was just released and had finished his shift and left, but had not fulfilled that obligation, or maybe he was returning back to clean out the trailer site, he was still completing these last tasks that he needed to get done?
Yes, Your Honor. And Juan Valadez's deposition discusses this at length. And Mr. Valadez explains, and again, it's uncontradicted, that the consequences for someone who doesn't clean up their trailer is that they get fined. But he's very clear that's not part of the job. If they want to avoid the fine, they go and clean it up. If they decide they want to pay the fine and leave for another job or go home, that's their choice as well. But there's no evidence that cleaning the trailer is part of their job. It's a convenience and a way of avoiding a fine, nothing more. In the time I have left, I would like to turn quickly to the course and scope analysis. Because even if Mr. Mueller were a Cameron employee and he was not, even if he was scheduled to work the next day and he was not, the court should still affirm because he was not acting in the course and scope of his employment. Now, this analysis is governed by Painter and Painter's clarification of the parameters, the special mission exception to the coming and going rule. The Supreme Court identified this test. A special mission occurs when an employee's travels involve the performance of regular or specifically assigned duties for the benefit of the employer. Notably, this test is based on this court's formulation in the Chevron USA opinion from 1993. Now, plaintiffs rely heavily on Painter, and opposing counsel cited this test, but the irony about their position is they don't really apply the Painter test. Instead, they attempt to redefine the test and apply a watered-down version based primarily on older workers' compensation authorities, which Painter did not adopt. According to plaintiffs, the test is an implied special mission to provide Cameron with an indirect benefit. They identify that benefit as ensuring a workforce of employees available and on call 24 hours. Now, with regard to the specially or regularly assigned duty, there is no evidence that anyone at Cameron told Mr. Mueller to make the trip to Pecos that night, nor is there any evidence that this was a regular part of his job. For the course and scope analysis to apply, the alleged special mission must still be of the same general nature as the job the employee was hired to do. Here, again, Mr. Mueller was hired to do one job, flowback well testing at the Blue Marlin well site, which plaintiffs admit ended several hours before the accident. He was not hired as a caterer. He was not hired as a food delivery person. No other part of his job as a well tester included bringing back food, water, or ice to the well site. In Painter, of course, Mr. Burchett got paid a bonus, and it was a contractual obligation that he drive crew members back and forth between the well site and the bunkhouse. But I'd like to also talk about the benefits of the employer. Plaintiffs say it's ensuring a workforce that's on call 24 hours a day, but it's uncontroverted and undisputed today. Mr. Mueller bought $38 worth of groceries only for himself, not for a workforce of employees. And Painter says that is not enough. The benefit to the employer must be broader. As the Fifth Circuit said in Pilgrim, which Painter cites, a special mission requires a benefit other than the mere making of the employee's own services available to the employer at his place of business. Here, there is no such broad benefit. Unlike Mr. Burchett and Painter, Mr. Mueller was ensuring only that his own services would be available by buying his own food, water, and ice. And whether he was on call or not is ultimately irrelevant. Even if he were on standby, that meant he was on call. And as this court has said in the JNC drilling opinion, that is insufficient as a matter of law. Unless the court has any further questions, my apologies, I will respectfully pray that the court affirm the judgment of the trial court.
Thank you, counsel. Mr. Laura, 1 second for the clock to reset, and anytime you're ready.
Thank you, and may it please the court. Oscar Lotta on behalf of David Boone Oilfield Consulting and Mr. Boone individually. I want to begin by addressing an issue that's not in dispute. The contract exists between David Boone Oilfield Consulting and H&J. And that contract establishes that Mr. Mueller is an independent contractor. Now, while the appellants argue that the Supreme Court decision in Painter changed the entire aspect of this relationship, but the Painter never changed the analysis with respect to whether somebody is an independent contractor. In fact, it reinforced it at 561 Southwest 3rd at 131, where it says that companies are insulated from liability of independent contractors. And this court's opinion in Painter versus Sandridge states that a contract is determinative of a worker's status. The only exceptions is if the contract is a sham or there is a different arrangement that happens subsequent to the contract, which it does not exist in this situation, and nor do the appellants argue. And here we have a contract that's determinative of the status of Mr. Mueller. Mr. Mueller is an independent contractor. Further, the argument that appellant said is that the contract was a sham. The appellants never brought any further evidence to really support that argument. They just claimed that because of some early discovery responses that Cameron made early on in the litigation, that was enough to say that there is some confusion as to the status between David Boone Oilfield Consulting and Mr. Mueller and H&J. But that was later cleared up as testimony from Mr. Valadez. He stated that Mr. Mueller was his own boss. He's his own independent contractor. He can do whatever he wants. Cameron, in their briefing in the summary judgment, as well as briefing before this court, have identified Mr. Mueller as an independent contractor separate from David Boone Oilfield Consulting.
Well, can I ask then, how does the fact of the workers' compensation insurance relate to the independent contractor agreement? I mean, how would you be able to cover the employee on workers' compensation and yet also assert that there's an independent contractor agreement?
Now, Justice Palafox, I think the way you address that issue is, first of all, that goes in many respects to a sort of a different issue. That goes towards a statutory reason, and if Mr. Mueller felt that he wanted to bring suit against David Boone Oilfield Consultant for any injuries he sustained, that can be addressed later on. But I think that goes more to our benefit that David Boone Oilfield Consulting was looking to provide to other contractors. There's nothing in the record that sort of suggests that, but at the end of the day, that's only sort of one minor aspect that goes into that. And if David Boone Oilfield Consulting wants to pay insurance premiums to provide its heads, the contractors with certain benefits, that's separate and apart as to whether or not there is any element of control, as there isn't here. It establishes an independent contractor relationship. And Mr. Mueller acknowledged that as such, as his testimony went uncontroverted, that he recognized himself as an independent contractor, that he realized that he can have the right to refuse a certain work. If David Boone Oilfield Consulting said, hey, look, there's work at this well site, you can take this job or not. Mr. Mueller says, you know what? I'm kind of tired. Or I just don't feel like doing this work, even though it may be a 1-week job or a 3-month job. Mr. Mueller had the right to refuse that type of work. And this goes back to what this court said with respect to Sandridge, that the right to control also has to extend to the specific activity from which the injury arose. Mr. Mueller was released, and there's been questions as to what that ultimately means, but ultimately at that specific time, David Boone Oilfield Consulting had zero control over Mr. Mueller's actions. In fact, David Boone Oilfield Consulting was not aware that Mr. Mueller even went into town with Mr. Valadez or went to go get groceries. This was all uncontroverted. In fact, David Boone Oilfield Consulting was unaware that what had happened earlier in the day, that they shut down the well.
Okay, so then the other question I had then is, after the collision happens, Mr. Mueller testified that he was asked to take a drug test on behalf of Boone. And so under what basis or what authority did Boone have to request that drug testing?
Well, it was requested from Mr. Mueller to see if he would care to volunteer. I don't think he was ordered, but ultimately the reason it was done is just in many respects with respect to Mr. Boone, as to whether or not this is somebody that Mr. Boone will ultimately care to keep as a contractor. Because if Mr. Mueller had tested positive for any kind of controlled substances or alcohol, maybe that's not something that he wants to be associated with, and he can terminate a contract at that point in time. But again, that does not go to any element of control or any type of actions with respect to how he performs his work, which is not really in dispute. Mr. Boone and David Boone Oilfield Consulting do not control how he performs his flowback operations. They do not provide any tools for that. They never supervise his work in general. Now, Mr. Mueller testified to that. Nobody's there is telling me how to do my work. Nobody's telling me how I can ultimately proceed. And in that respect, that again shows the independent contractor relationship that existed between David Boone Oilfield Consulting and Mr. Mueller. And believe I'm thinking—
You have a minute.
Okay, trying to read the clock there, I apologize. And again, we go back to the limestone factors that we ultimately looked at. Mr. Mueller decided how he wanted to arrive at the scene. Justice, I don't know if you had a question.
I did. In the time you had left, I wanted you to address Ms. Levy's contention that Mr. Boone in his deposition expressed that he was the employer or I guess had the right to hire and fire and issues like that.
The record there reflects with Mr. Boone's testimony, Justice Ali, is that essentially on extreme situations, if Mr. Mueller was behaving incorrectly, which I believe Cameron would have the right to tell Mr. Mueller, get out of here. That's essentially what he's saying. Or if based on what he's being reported, he's saying, no, that's it. We're going to stop you. But that's more of in the extreme scenarios, not on a day-to-day basis. And I see that I am out of time. And for this, I ask that this court affirm the trial court's decision to grant summary judgment on behalf of David Boone Oilfield Consulting and Mr. Boone.
Thank you, counsel. Ms. Levy, do you have any rebuttal?
Just briefly, Your Honor. Thank you. I don't want to sound like a broken record, but the evidence that they're saying is not controverted, it's controverted. I mean, and I think we've laid it out in our briefing, But I want to specifically look at the notion, forget the standby, forget the next job. I want to look at the notion that this job ended before this collision occurred, because there's a ton of circumstantial evidence showing that it didn't. Again, we've got, just to sort of set the stage at this well site, we've got 2 people working during the day, 2 people working at night, 1 Cameron, 1 Boone. Well, the Boone people are paid a day rate, the Cameron people are paid hourly, but everybody's paid to work 24 hours and to be there 24 hours. So just as a technical matter, he's paid to be there 24 hours. Whether they chose to let him go early or not, he's paid to be there for 24 hours. Again, we're looking at right to control, not whether they actually exercised it. So that's one. The well flowback work, just because you stop the testing, the job doesn't end, right? All the equipment's still there. They have to wash it out. They have to rig it down. There's a series of steps that have to take place. Now, the contention was that he was only hired to do flowback testing work. And when the flowback testing work stopped, he was done. Well, so was Corey Johnson, who was, again, the Boone person working at night. They were both hired to do the same thing. He was there all night working on this washout. Juan Valadez, who was Mueller's counterpart, showed up to work, was called to work the very next day, and would have worked the very next day, but for this accident, which shut everything down. And again, I go back to the issue that the jury has to decide. Did the job end and was there an accident, or was there an accident and everybody decided the job was going to end? And I think that's where the circumstantial evidence, again, we're at summary judgment, becomes key in terms of determining when the job ended. And of course, we have, in addition to this particular job, and again, as you were saying, Justice Palafox, he comes back to the well site that evening to sleep in the trailer. He was going to do that whether he had the collision or not. Again, if he was going to go home because the job was over, why does he go buy groceries, water, and ice to continue working? It's just, there's no explanation for that. No one's ever come up with an explanation for that. And so again, these are just fact issues that we think the jury has to consider, and in this case. And then I also want to briefly address this notion of the contract and workers' comp, and that, you know, that contractors can't decide whether workers are employees. But I just, it reminded me of the Exxon v. Perez case, which came up in the workers' comp context, where, and that was a borrowed servant case. And the Texas Supreme Court says a contract between 2 employers providing that one shall have the right of control over certain employees is a factor to be considered, but is not controlling, which is where I go with this is something that the jury should look at in terms of right to control and an employment relationship. So again, unless the court has any questions, we believe there are multiple material fact issues on this record, and we believe under Painter and the appropriate summary judgment standard that the opinion below must be reversed.
Thank you, counsel. Thanks everyone for your excellent briefing and for your arguments today. Your case will be submitted on the briefs and the arguments, and hopefully you'll hear from us soon. Thank you so much.
Thank you.
Your Honor.
Thank you.